of India. Let's cut across to that. The Apex Court has referred the question of constitutionality of the sedition law, which is already in abeyance, to a larger bench. A larger bench of at least 5 judges will decide on the constitutional validity of sedition section under the Indian Penal Code. The section, which has already been put under abeyance by the Supreme Court of India, the centre was of the opinion that this hearing should be deferred since there is already a proposal pending before the Parliament that under the new Bharatiya Janata sedition law ought to be repealed. However, the Supreme Court is of the view that the new law is only under consideration right now and at present has no bearing on the present proceedings before the Apex Court. Ananya with us on the broadcast. Ananya, put that into context for us.
So yes, the Supreme Court was basically hearing a batch of petitions challenging the constitutional validity of Section 124A of the Indian Penal Code that deals with the offence of sedition. And now, in fact, the topmost of the country has taken a decision to send the matter to a larger bench of at least 5 judges. And what is very, very clear and categorical to note at this point of time, Anusha, is that the Supreme Court was of the basic view that since this is a law that would not be applying, even if a new law comes in, that would not be applying retrospectively, it would be a prospective effect. That's the reason why, in fact, and already there are a lot of cases pending and there are a lot of trials which are at halt since the law was put into abeyance for a long time. There has to be a decision on the constitutional validity of Section 124A that needs to be decided. And that's the reason why, in fact, it has now been sent to a larger bench of at least 5 judges. Another important development that took place before the topmost of the country was that the central government was continuously arguing that this matter should be
We seem to be losing your audio. Why don't we connect with you once again? There's a problem with your audio there. But as Ananya pointed out, one of the arguments that the union government had put forward before the Supreme Court is that since the matter is already under consideration of the Parliament, it should not be heard. The constitutional validity should not be heard, ought to be for 2 reasons. One is that the section is already under abeyance. The law is not operative in India. And the central government itself is arguing that we'll come up with the law in a new form. We will not have the law in the present form. Ananya, what were the key objections that the bench had, and why did they not accept the suggestion of the union government? Why has it been referred to a larger constitutional bench despite the law being in abeyance right now?
Well, Anusha, the law is in abeyance at this point of time, and now since the matter is before a larger bench, the major problem that the bench had, and in fact the petitioners too raised, that there are certain things that needs to be looked into, just like the trials that are pending for quite a long time, and even if a new law comes in, though it's still into a parliamentary consideration, this is not a law at this point of time, and if that might take some time, and also that there are already a lot of cases pending. There are a lot of trials that are, halted because of the law being in abeyance. If you remember that the case with regards to Sharjeel Imam and his speeches of during the 2019 Jamia violence and various other cases of such nature are, at this point of time under abeyance because of this particular law. The bench felt it very, very clear that the Kedarnath Singh judgment, which had struck down the constitutional validity of 124A, should be referred to a larger bench of at least 5 judges. Remember that Kedarnath was it had been a contention for quite a long time that the matter should be referred to a larger bench, and now finally the topmost court of the country has referred it to a larger bench of at least 5 judges, and very clearly various questions would be of law would be dealt by in fact the larger bench whenever it's constituted by the Chief Justice of India, Dr. Justice Chandrachud. But the centre clearly maintaining its stand that this should not be the matter should be deferred adjudication since it's already before the Parliament of India. But very, very clearly and politely, the CJI refused this request and said that the matter is going before a larger bench.
Thank you, Ananya, for putting that into perspective. Keep tracking all the details coming in from the corridors of the Supreme Court. Let's now cut across to some breaking news.